Senator Sullivan.
Thank you, Mr. Chairman, and just feel a little bit compelled. I wasn't going to mention anything, but since Senator Merkley brought it up, you know, there's a lot of senators who don't think that was a good day yesterday in Alaska with what Shell decided to do, and I think our regulatory system is largely to blame. 7 years, $7 billion to try to drill one well in America. The EPA certainly shares some of the blame. We're going to undermine our energy security, certainly undermine jobs that people need in this country. But one issue that doesn't come out, we're going to undermine the environmental protection in the Arctic. What are we doing? We're driving investment to Russia, to China, to countries that don't have high standards like we do. So I think when we're celebrating this, we need to actually have a better understanding of the environment. And I certainly will oppose any maneuver by the Arctic Council to try to limit responsible resource development in the Arctic. But Administrator McCabe, I want to talk, Senator Carper mentioned the importance of clean air, a strong economy. I agree with that. But I also think we should all be very concerned about making sure your agency follows the directions of Congress, follows the rule of law. And do you think that any statutory or any action that you take from a regulatory standpoint has to be based in statute?
Our regulatory actions are based in our statutory authority, Senator.
Good. I'm glad you think that. You know, in terms of the Clean Air Act, you've actually lost a couple of pretty important Supreme Court cases recently, the Utility Air Regulator case, the Michigan versus the EPA case. In the Utility Air Regulator case, the Supreme Court stated, when an agency claims to discover in long extant statute and unheralded power to regulate a significant portion of the American economy, we typically greet that announcement with a measure of skepticism. They went on to say the EPA's interpretation is unreasonable because it would bring about an enormous transformative expansion of the EPA's regulatory authority without clear congressional authorization. Do you think you have clear congressional authorization to undertake this rule?
We do, and our authority has been supported by the Supreme Court finding that carbon pollution endangers public health.
Okay, so in the WOTUS, when you were getting ready to issue the WOTUS rule, I asked the administrator if we could get the legal opinion that the EPA undertook to show that you had that authority. She never granted it, never gave it to me. I think that's a clear aspect of our oversight. She refused to do it. Do you have a legal opinion? I'm not talking about your rule, but a detailed legal opinion that shows that you have the legal authority to issue the Clean Power Rule.
We do, Senator.
Can we get that?
We have a legal memorandum.
Can we get that?
Absolutely. It's available right now today. It's been available for since August 3rd in the docket, and we'll be happy to provide it to you.
Great. In the Michigan versus EPA case, the Supreme Court ruled that EPA's mercury rules, against the mercury rules 3 years after their issuance. As such, many power plants had already shuttered or retrofitted because of the rules requirement. Earlier this year, the Wall Street Journal ran an editorial suggesting that this might be a tactic of the EPA. And interestingly, the Administrator McCarthy kind of insinuated that as well. She was on a TV show and she stated, on the eve of this ruling, we think we're going to win because we did a great job. This is EPA versus Michigan, which you actually lost. But even if we don't win, it was 3 years ago we issued the rule. Most of them are already in compliance. Investments have already been made. Do you think that's an arrogant way to approach the rule of law and our oversight? Saying, hey, even if we lose, we're going to win because we force this on Americans anyways?
Senator, this agency acts within its understanding of the law.
What do you think of her statement? What do you think of that statement? You think that's an arrogant approach to our oversight or the American people? We lost, but you know what? The American people and businesses have to abide by it anyways?
If I can clarify, Senator, the decision from the Supreme Court spoke to one very narrow aspect of the mercury and air toxic.
No, I'm talking about her statement.
I understand that, and I'm not going to comment about the administrator's statement. I didn't hear her say it. I don't know what she was intending to say.
Mr. Chairman, I think that that's an incredibly arrogant way to look at the rule of law, to look at our oversight of this committee, and I think it's something that we need to look at because it's a flagrant disregard for the rule of law. Let me ask one final question. You talk about outreach. 31 states, including Alaska, are suing the EPA on the WOTUS rule. You're losing right now in federal court. There's been an injunction saying it's likely that you're going to lose. 32 states have opposed the Clean Power Plan. Does this disturb you? You talk about all the outreach that you do, and yet the majority of the states in the United States consistently oppose what the EPA tries to do from a federal regulatory standpoint. Does it disturb you that 31 states are suing on WOTUS, 32 are opposing the Clean Power Plan, and 16 have already requested a regulatory stay, but they can't do it because you haven't issued the rule? Does that disturb you or the administrator?
Senator, I can't speak to the WOTUS rule because that's not within my area.
But you're a senior EPA administrator.
I am, and our desire always is to work with states. There will always be disagreements among states. Even within the states that have taken action to litigate against the rule or have indicated that they intend to, we're having very constructive discussions with those states. I think it's oversimplifying to say that X number of states oppose the Clean Power Plan.
When the states sue you, that's usually a pretty good indication they don't like the rule.
I don't think 32 states have sued us.
They can't sue you yet on this one because you haven't issued the rule.
And attorney generals are taking certain positions, governors are taking certain positions, but the vast majority of the people that I talk to understand, they appreciate the adjustments that we made in the final rule that were directly responsive to the concerns that they raised to us, like providing more time for states to get their plans in, providing more time for utilities to accomplish these goals.
Thank you, Mr. Chairman. I do think it's a big issue, whether it's the arrogance that the administrator shows by saying that, hey, even if we lose, we win because the American people are stuck with it anyways. And I think it's a really big issue that we need to look at to not allow for agencies, even when they lose in court, in the Supreme Court, to still force a rule down the American people's throat and have the administrator essentially say that's part of her strategy in public. I think it's outrageous.
Thank you, Senator Sullivan.